Hi everyone, and welcome to our QCE Legal Studies Units 3 and 4 lecture for today. My name is Jess, and I will tell you a little bit more about me. But first off, I want to tell you a little bit about ATAR notes for anyone who isn't familiar with us. So this lecture series that we have every year throughout the year is just one of our offerings. We've been doing the lectures since 2015, but our mission is to help students with as many free resources as possible. So we have a whole bunch of other resources that can help you if you feel like you need a little bit of a boost with any of your subjects. So let's have a look at some of the things that you can get access to. So if you go to our website, you'll be able to find newsletters, ATAR calculators, articles, videos, discussion notes, heaps of different resources that are about all of the different subjects that you may be doing. And a newer offering that we have is also called ATAR Notes Plus. This gives you even greater access to even more resources. And we do have different textbooks that are dedicated to discussing the different syllabus requirements for all of your different subjects, whether it's humanities subjects like legal studies or other subjects like your science subjects, maths, English, etc. So I definitely encourage you to find out more about these things if you're interested. I wrote the accounting and the business notes for Queensland, and back in year 12 I also accessed all of the different notes for other subjects as well, and that was really handy for my external exam preparation. So get around that if you are interested. So a little bit more about me before we go into our lecture for today. So as I mentioned, my name is Jess. I graduated back in 2020 and I'm currently studying communication and journalism at the University of Queensland. And I love reading and writing, so English and humanities subjects like legal studies, accounting, and business were all my favorites. And so hopefully I'll be able to help you with some useful legal studies content today. So let's have a look at what we'll be covering in today's session. So the way that your syllabus is arranged for legal studies is your previous unit you may be doing now or you may have just completed will be an inquiry report. That's based on topic 1 and topic 2 in unit 4. So then part of your external exam, which is your next piece of assessment after that, is also on topic 1 again. So there's a bit of repetition there, but then instead of on topic 2, it's also on topic 3. So topic 1 is human rights, and in that we'll be looking at describing different legal terms using the correct terminology. We'll be looking at the International Bill of Rights, principal treaties, treaty obligations, the role of reservations, and the role of different organizations and different pieces of legislation in human rights. And then in topic 3, we're looking at human rights in an Australian context. So with an Australian lens, what are the rights that Australians have in different contexts? What are the legal processes that are available for resolving human rights complaints in Australia? And what are the role of different groups in protecting human rights or advocating for human rights in Australia? So let's get started. Topic 1 is human rights. So this is we'll have a look throughout at the different syllabus requirements as we go through, so you can see exactly what you're required to do, and we'll cover all of that content. So you have it all with you to help you prepare the best that you can for your exam. So the first aspect of topic 1 is being able to describe your key terms. And those key terms range from human rights to royal commissions and everything in between. So let's get stuck into looking at each of these. So human rights are the fundamental rights that all people have by virtue of being human beings. So just because we're humans, we have these rights, and it doesn't matter what race we are, our gender, our age, nationality, or religion. So everyone has the same rights. They're fundamental and they're equal for everyone. So they are defined as the supreme, inherent, and inalienable rights to life, to dignity, and to self-development. So human rights are defined internationally, nationally, and locally. So different countries can have different human rights and different definitions of human rights, because we've got those different levels and different lawmaking bodies in each of those areas. So, in terms of the Australian context, we've got a bunch of human rights that you're probably familiar with. Things like a fair trial, privacy, adequate standards of living, life and liberty, education and work are all our fundamental human rights. And we'll have a look soon as well at the different types of rights in terms of express and implied rights. But these are those fundamental human rights that are express and that everyone has in Australia. So, states. Now, this is something that can be a little bit confusing because when we think of states, usually we think of Australia as having lots of states within it. So, we've got Queensland, New South Wales, Victoria, etc., and all of those districts are states. But in human rights, states have a different meaning. So, states are actually countries that are recognized as having legal standing under international law. And the different criteria that are needed to be defined as having that legal standing are these. So defined territory, one government, and a permanent population. And they also need to have the ability to enter into relationships recognized by law with other states, so other countries. So territory is about the area. We know that the area that Australia covers is defined. That is defined as Australia. One government. We have one government in this country. We also have a permanent population, so people are permanently living here, and we do enter into relationships and negotiate with other countries as well. So those are the things that are required to be recognized as a state with legal standing in international law. So in human rights, Australia is a state. We have a bunch of different terms that are often used interchangeably, but it's important to have an understanding of each of them. So covenants are binding agreements between states. So they're a type of treaty, and that's why these different terms are often used interchangeably. Now, treaties are also formal agreements between two or more states that define and modify their mutual duties and obligations. So they're entering into an agreement, and that agreement is putting into words what their obligations are, what that country is required to do for whatever it is that agreement is on. So the term treaty is often used synonymously with both convention and covenant. And we can see there at the bottom, those three terms all basically mean a legally binding agreement between states. So a convention as well is a binding agreement, and it's also used synonymously with those other terms. But conventions are stronger than declarations. So declarations is a different category because conventions are legally binding for any government that have signed them, whereas a declaration, when you think of that word, it's about declaring something, saying something, but that's not actually in writing. It's not an official thing that's binding. So when the UN General Assembly adopts a convention, it creates international norms and standards. And once that convention is adopted by the General Assembly, member states can ratify the convention, which means that they're promising to uphold it. We'll have a more detailed look at ratification shortly. But governments that violate the standards set forth in a convention can face some kind of consequences from the UN as a result of that, because they've made this legally binding agreement. They've introduced potentially legislation that upholds the ideas that are contained in the convention, but then if they violate that, then they would face some kind of sanctions as a result. We have two different types of treaties. One of them is multilateral. So this is about more than two nation states are forming an agreement. And that we can, of course, take from the part of the word multi, which is just like multiple, more than two. And bilateral is a formal agreement entered into by two nation states, and bi means two. So that's how you can remember that difference between those two categories. Now, a signatory treaty. So the term signatory is referring to a state that is in political support of a treaty and is willing to continue that process, continue the engagement with the treaty process to potentially result in some legislative changes and ratification. But it's just that indication of support, and it's not quite that official level yet. So this is about intent. The intent is codified as a signature, as the word implies, and that signature is submitted to whatever the international body is that has power and oversight over that particular treaty. And in a state that is a signatory to a treaty, that means that the treaty hasn't entered into force in that area yet. So it isn't an official piece of legislation yet. Now, ratification is the next step up. So this is when a signatory country, so a country that has submitted its signature to say that it is intending to follow that treaty, this is when the country is actually implementing domestic legislation to uphold that treaty. So the process of full adoption of the obligations imposed by a treaty or covenant into Australian law for us, or it could be another country, by the passing of legislation through the federal parliament that mirrors and enacts the treaty obligations. So you're signing you're signing up to this idea of the treaty, and then you're actually ratifying that, solidifying that promise by implementing the legislation that reflects the principles within the treaty. So, a little bit more of a look at the difference between signing and ratification. So, Australia is a party to the United Nations Convention on the Rights of the Child. And so each state has legislation that protects children to uphold the principles of that convention. Now, for example, in Queensland, we have the Child Protection Act, and the principles are also mirrored in the Family Law Act, which is a Commonwealth Act. So signing is that idea of expressing the intention to comply with the treaty, and for this example, that happened back in 1990 in August, but then implementing the domestic legislation to ratify the treaty didn't come until December of that year. So you can see that there's a little bit of a gap between uh, indicating that you're going to continue that process and sign up for that treaty, and then actually implementing the legislation. There are processes that would have to take place for the legislation to actually be passed and drafted and all of those processes. So that's why there's a bit of a delay there. Sovereignty is another concept that you may have heard of before, and it's something that you need to be able to describe as part of this unit. So, this is the concept that a government exercises full control over everything that's happening within a geographical or territorial limit. So, it can pass laws and it can enforce those laws in that area, and it exists as an essentially independent legal and political body as well. So it has full control, and the laws and the processes of other countries are not relevant here because it has control over its territory. So Australia, as a nation state, claims sovereignty over its territory, and then by default, that means over the people within that territory as well. But this isn't necessarily straightforward for Australia and for any country that has sort of groups of First Nations people and Indigenous people. So, for example, in Australia, sovereignty is not something that all First Nations people believe um, they ever relinquished. So they thought um, that because Australia was invaded uh, by Captain Cook and people from overseas, they have said before, and some people continue to say that they haven't relinquished their sovereignty because it was never something they agreed to. This was originally their land, and they will always be our First Nations people. So in Australia, sovereignty is vested in the Crown in Parliament, so the monarch and the Parliament. So we have our monarch over in England, um, and and then we've also got the Parliament here in Australia with the Australian government. Bill of Rights. So a Bill of Rights is another type of formal declaration, and it is a declaration of the legal and the civil rights of citizens in any state, country, or federation. And it's all about protecting the rights of individuals from being violated by anyone, whether it's the state itself or individuals within that state. A royal commission, that's something that a lot of us would have heard of before. So, in the Australian system of government, it's the highest form of inquiry. So, we've got lots of high profile issues that have had royal commissions to find out more information about what has happened, what the situation is with things that are concerning in society. So, it's independent of government, and it's about matters that are of public importance and usually public concern. So they have broad powers, the royal commissions, and there's lots of different processes that can take place as part of royal commissions. You can have public hearings, call witnesses under oath, and compel evidence from lots of different sources. Royal commissions make recommendations to government about what should change. So it's all about conducting a really in depth investigation, lots of research into the issue, writing a report that includes recommendations and handing that down to the government for it to consider and ideally act on. So the next section of the syllabus, you need to be able to describe the main features of international law that are developed from the International Bill of Human Rights. And we've got a few different aspects to look at here. So let's go through each of these. First of all, the Universal Declaration of Human Rights. So this is a document that was written by representatives within different legal and cultural backgrounds. So the idea here is, of course, people from different backgrounds are going to have different things to bring to the table, different perspectives on issues, different understandings of what's important in society and how society should work. So, so this Universal Declaration was written by a range of different people to make sure it was reflective of that diversity that we have in the world. And then the Universal Declaration, it sets out all the fundamental rights that require protection from all the different nation states. And it includes civil and political rights, so things like the right to life, to liberty, and to privacy. And it also includes economic, social, and cultural rights. So the right to social security, health, and education are examples there. So it's a pretty broad example. And then on the other hand, we have more specific ones that are within the International Bill of Human Rights. One of them is the ICCPR, or the International Covenant on Civil and Political Rights. So there are a number of things that are encompassed in this. Overall, it declares that all people have a range of civil and political rights, and it was adopted in 1966 and entered into force in 76. So some basic human rights that it includes are the right to life. You can see here that there are overlaps between things. So the Universal Declaration of Human Rights also says that we have the right to life. So there is overlap with what these different pieces cover. But the ICCPR also says that we have the right to a fair trial and freedom from torture. Now, most rights are not absolute and are subject to limitations for legitimate purposes. So we, as I mentioned, will look at this idea of express and implied rights. Here, this is about being absolute or not absolute is a little bit different to express and implied. Basically, absolute means that there's no limitations, there's no exceptions, but in most cases, rights aren't absolute because there can be different scenarios, different circumstances that make it legitimate for that right to not be relevant in different scenarios. And another one is the International Covenant on Economic, Social, and Cultural Rights. So this declares that all people have a range of rights in these areas, and we can see some examples down the bottom here. So you can see that there are a lot of social rights, but in terms of economic, right to employment, right to enjoy just and favorable working conditions, and to form a union as well. So we often hear about different unions in Australia. So we are a signatory to this covenant. So everyone in Australia has the right to form a union. For example, there are teacher unions, and they advocate for teachers' rights. So favourable working conditions, when we hear about people who aren't paid correctly or don't have safe or sustainable working conditions, in factories or whatever that situation may be, we hear about how it is a violation of their human rights. So that comes under this convention. Social is really broad. So we've got things like right to training, right to social security, protection of the family unit. And you can see as well there are some things that are a bit of an overlap, because of course things that relate to society also often relate to the economy. Society is kind of integral to everything. So working conditions is also part of the social as well as the economic. The standard of living, education, physical and mental health are all social. And then cultural, the right to take part in culture. So all of the different cultural things that we have in society, different different things that you can go to, festivals, different things like that. We all have the right to take part in our culture. The next part of the syllabus is about principal treaties. So we'll have a look at 4 different principal treaties and the main features of each. So you may recognize this family from Billawheeler, and this is an example of the implications of the Convention relating to the status of refugees from 1951 and the Protocol relating to the status of refugees from 1967. So both of these, this convention and the protocol, provide provisions to protect and support refugees. The purpose was to identify the conditions in which a person would be considered a refugee. So what is the definition of a refugee? And then providing legal rights, recognizing that people have the right to seek asylum from persecution in other countries. So, so here through these pieces of these treaties, we understand what a refugee is and what their rights are. So this family from Billawheeler were originally assessed not to be refugees in Australia. And this was the argument that was used by politicians to support their claims that Australia did not owe the family protection. But ultimately, back in 2021, when the Labor government got into power, one of their promises was to allow this family to stay in Australia, and they upheld that promise. Uh, so this family is now still living in Billawheeler in Queensland. But you can see how these different treaties uh, and what they say about the rights of people do play a role in political decisions and certainly in the way that refugees and their situations are handled. So, a little bit more of an overview of each of these. So, the 1951 Convention elaborates on Article 13 of the Universal Declaration of Human Rights. So, as I mentioned before, we do have overlaps between different treaties, protocols, conventions, all of the different words we can use to describe them. Um, so the Universal Declaration is quite broad. It's covering lots of different areas and lots of different rights. And then we do have all of these more specific treaties as well. So in this case, we've got the 1951 Convention that's elaborating on those more general principles set out in Article 13 of the UN Declaration. So it includes the core principle of non refoulement. So that means that a refugee should not be returned to a country, so sent back to a country where they face serious threats to their life or their freedom. It also includes the provision that arbitrary detainment is illegal and penalties are not to be awarded based on illegal entry. So if a refugee illegally enters a country, they can't be penalized because of that. And it also includes the provision of public education in Article 22. So refugees have that right to receive an education in the country that they're in. The 1967 protocol broadens the applicability of the 1951 convention, and it also removes the geographical and time limits that were part of the 1951 convention. So there were different limitations there, and years later in 67 they recognized those limitations and that they shouldn't be there, so those were able to be removed as well. The International Convention on the Elimination of All Forms of Racial Discrimination. This was from 1966, and it requires that racial segregation, criminalization of incitement of racial hatred, and promotes understanding and tolerance. So, so they want to get rid of racial discrimination and segregation in society. They are saying that inciting racial hatred is a criminal offense, and it's also saying that they want to promote understanding and tolerance in society, so we can all be united regardless of our race. Convention on the Elimination of All Forms of Racial Discrimination Against Women. You can see that different groups of people who are minority groups or have faced discrimination in the past, and in some cases continue to face discrimination, tend to have dedicated conventions relating to eliminating discrimination against them, because over the years it's been recognized that they have discrimination against them, that they are minority groups. So those pieces of human rights legislation have come in to try and help with that. So in this case, the Convention on the Discrimination Against Women outlines all the non-discrimination requirements and also women's rights. So regarding a whole bunch of different areas like political life, representation, and rights to nationality, education, employment, and health. So some main features: the idea of substantive equality, non-discrimination, and state obligation. So let's have a look at what these things mean. So substantive gender equality requires that equality is interpreted according to the broad context or the realities of women's disadvantages and the impact that their circumstances have in terms of eliminating disadvantage. So it's not easy to just compare different groups. It's not straightforward to compare different groups. So this is saying that we need to look at the disadvantage that women in particular face and make sure that this idea of equality is looked at from that broader context to make sure that those disadvantages are factored in. State obligation is the concept that a state that is party to the convention is legally obligated to take all appropriate measures to eliminate discrimination against women and advance gender equality. So it's the obligation of all of the different states that are that are signing up to this convention. The Convention on the Rights of the Child, 1991. We mentioned the rights of children earlier, so we'll have a bit more of a detailed look here. So, the main feature of this convention is non discrimination, which is all about this idea that children have rights regardless of who they are. So, regardless of race, color, sex, language, religion, political or other opinion, national, ethnic, or social origin, property, disability, birth, or other status. So there's heaps of different things that make each person unique, each child unique, and none of them should be used as something that children are that is held against children. So children should not be discriminated against based on any of these things, and indeed, no one should be, because it doesn't matter what these things are for a person. It doesn't matter what our background is. We should all be treated equally. We should all have the same human rights under the law. So, children's rights in the convention include the right to be treated fairly, to have a say about decisions affecting them. And that's something that's really important because often it's this case of children not having the knowledge and the maturity to be able to make decisions by themselves. And often it's adults making decisions on their behalf. But this convention is recognizing that they should actually have a say about the decisions that affect them, because ultimately it is about them and they are still people. They also have the right to live and grow up healthy, to be safe no matter where they are. They have a right to an education and the right to play and have fun. So, another feature is this idea of the devotion to the best interests of the child. So, the child's best interests must be the primary consideration whenever we're making decisions about children or affecting the child. So, so when we hear about different legal cases in society, we hear about how uh, this decision was in the best interests of the child. That could be from different perspectives. It could be the safety of the child, the health of the child. It could be from an education perspective, a financial perspective, all of those different considerations that may play a part in what's in their best interest. So, respect for the views of the child. So, this is the idea that children have the right to express themselves freely on matters that affect them and to have their views taken seriously. So, yes, they are children. They haven't reached that 18-year mark, but they still have opinions. They still have the right to express those views and to not be treated as lesser than, or to not be treated as though those opinions that they have aren't valuable. They also have the right to life, survival, and development. So there's some very basic ones that would be covered in other documents. So the Universal Declaration of Human Rights, the ICCPR are also covering the right to life. And then we have, for all of these specific conventions for the different groups like women, children, etc., we often have some overlaps, but then also some building on those more general principles, some more specific things that relate to that particular group or that particular issue. So in Australia, in terms of children's rights, we don't have the Convention on the Rights of the Child embedded in our domestic legislative framework. So we do have some child rights issues. We've got this idea of the age of criminal responsibility. So children as young as 10 can be arrested and jailed, and the UN has called for this age to be raised to 14. So when we aren't embedding different legislation, that means that we don't need to follow uh, the convention because we haven't ratified it yet. And in this case, that means that Australia is able to not follow what the UN believes is the right path to follow. Another aspect is child labour. So you must be 15 years old to enter into labour practices. There are some exceptions to this, like in the entertainment industry, you might be doing work there with acting or things like that and be below 15. But that's a general rule. And the right to get an education as well. So school is mandatory for 6 to 17-year-olds. There are, of course, exceptions to that as well. Some students choose to leave school early, but they have to have a job. There are certain requirements there. Have to have a job or have to have another path that they're taking with education, for example. Part 4 of the syllabus that we're looking at is covering the process of treaty obligations being translated into domestic law. So we're going to look at accession and ratification, the role of reservations, and the effect of the Human Rights Act. We'll look at the rights of states. Some of these things we've touched on already, but we're also going to be looking at particular articles in the United Nations Charter. Then the different roles of different agencies as well. Okay, so explaining the process by which treaty obligations translate into domestic law through accession or ratification. So, not only do you have to be able to just describe terms, you also need to be able to explain them. And often, you need to understand the relationships between things as well. So, our analytical verbs describing is less detailed, whereas explaining, we often need to have examples. We need to have enough knowledge to be able to write full sort of paragraph responses to explain things. So that's why here we'll be able to look at examples of how you could explain these different concepts we're going to look at. So, treaty obligations translate into domestic Australian law when they undergo um, one of two processes. It could be ratification or it could be accession. So, ratification, like we've mentioned, is the process of fully adopting the obligations imposed by a treaty into Australian law. And this is the idea of passing that legislation on that federal level that is mirroring and enacting those treaty obligations. On the other hand, accession is where a nation state, such as Australia, enters into a treaty that has already been formed after it has been negotiated and signed by other states. So it has the same legal effect as ratification, but the difference here is just the timeline of when things are happening. So here we've got this idea of negotiation. So other states may have already implemented the convention or the treaty, but this country, so in our case Australia, um, may have a delay in doing that, and that would be extension. So the role of reservations. Now, this is important for what we were just touching on. So when you are negotiating as a nation um, for a nation to indicate it will sign the convention or covenant or treaty, um, you may also make some reservations. So just like in your everyday life, you may be saying that you're interested in something, but you do have some things that you're not so sure about, and you want to discuss them further and negotiate them. So uh, it's possible to say what those reservations are about the obligations under the conventions. So any kind of protocol amendments or supplements to an earlier treaty or agreement. So let's have a look at an example. The International Covenant on Civil and Political Rights, or the ICCPR, is a multilateral treaty, so it's ratified by many nation states, more than two, and it's binding on states that ratify it. Australia became a signatory in 1980, but it has reserved certain rights in relation to some of the provisions. So, for example, Australia didn't agree to the provision that all juvenile offenders must not be held in custody in adult prisons. So that's why that still happens in Australia, because we've not agreed to that provision as part of the ICCPR, and that's something that that other nation states may disagree with, because they may have not reserved their right um, to go against that part of the convention. So, an example of a paragraph response to explain the role of reservations. So, it's a unilateral statement made by a state whereby it is basically promising to it, or it's saying that it's going to exclude or alter the legal effect of certain provisions of the treaty in their application to that state. So it's saying overall we are agreeing to this treaty or uh, this convention. However, we aren't agreeing to this specific aspect of it, and we don't need to follow the different things that it's outlining in that section of it. So, the role of reservations is to enable a state to accept a multilateral treaty as a whole by giving it the option not to apply those certain provisions which it doesn't agree with or it doesn't want to comply with. So, reservations can be made when the treaty is signed or when it's ratified, accepted, approved, or acceded to. You've got lots of different options there with the timing. Reservations must not be incompatible with the object and purpose of the treaty. So, of course, there are some limitations to this. We can't just say, yes, we agree to this treaty, but we're not following this aspect, this aspect, this aspect, because there would get to a point where you're actually not agreeing to anything. You're needing mainly to follow the most of the principles in a treaty and then just have some reservations potentially. Otherwise, it would be incompatible. So, a treaty can also prohibit reservations or only allow for certain reservations to be made. So, if a treaty has certain kind of um, certain ideas embedded in it that are really important, um, something that really, if you go against that, if you have a reservation about that, then really it's not compatible with the overall idea of the treaty. That could be stipulated as a reservation that can't be made. Yeah, so there are limitations there to make sure that basically things can work, and that everything is compatible. So it's good to have this idea of reservations, but it does have to have limitations for it to function logically. Next up, let's have a look at the effect of the Human Rights Parliamentary Scrutiny Act 2011, which is a Commonwealth piece of legislation. So there are two processes outlined in this act, and the one of them is the requirement of a statement of compatibility to accompany all proposed legislation, and another is the establishment of a parliamentary joint committee on human rights. So we've got to have this idea that all of the legislation that we have in society has to be compatible with other rights, other parts of society, other legislation that already exists. So that's where the statement of compatibility is providing that assessment of the compatibility of that legislation with the rights and freedoms recognized that in the other human rights treaties that Australia has ratified. So in Australia, we've got 7 human rights treaties that we've ratified. The intention behind this is that those that restrict or interfere with the human rights that are recognized in those other treaties will be flagged for reconsideration, and possibly amendment as well. So again, this is that idea of compatibility of things that already exist needing to align with anything that is being proposed to be introduced. You can't just introduce everything without considering what's already there. And then the PJCHR has a gatekeeping role. So this is the Parliamentary Joint Committee on Human Rights. So it has to examine bills, legislative instruments, and acts to look at the compatibility with human rights. And it also conducts inquiries into any human rights related issues that the Attorney General refers to it. So the whole idea of this is it's ensuring that when the Parliament is developing policy and legislation, human rights are always considered in the decisions that are made. So when we look at the title of this act, it's about parliamentary scrutiny. So it's about keeping the government accountable, making sure that we've got that compatibility, we've got that oversight, so everything is working together cohesively rather than having contrasts between different things that are introduced. The rights of states. So we've looked already at sovereignty, but let's have a look again. So this is that idea of exercising full control over affairs within a geographical or territorial limit. So it can pass laws and enforce them within that area, and exists as an essentially independent legal and political body in this space. And equality. So, sovereign equality is the concept that all sovereign states, so any state that's deemed to have sovereignty, are treated equally in international law, and their right to make laws for their own territory will be respected. So, they have the ability to make laws for their area, and that needs to be respected by the broader international society. So the rights of member states are not dependent on size, economic, political, or social power or circumstances. So if you've got sovereignty in a nation state, then it doesn't matter what size or sort of standing or status you have, your rights are the same as any other nation state. Another right is political independence. So this is the concept that within the territorial boundaries of a state, so that same idea of the territory. So again, you can think of the borders of Australia. Within that territory, the state has the right to an independent political system of its own choice, and it should be free from interference from any other state in how that is exercised. So we've got different countries all over the world that have different political systems. Even countries that we are allies with have different political systems. So, for example, the United States has the presidential system, whereas here we have a prime minister. The United States doesn't have compulsory voting, whereas in Australia we do. So we've got all these different political systems depending on the different areas, and every area, every territorial boundary of a state uh, is allowing that state to have the right to choose its own political system and not be facing interference from any other state to try and change that. Territorial integrity is the idea that a state has the right to its own territory, and again, another state shouldn't do anything to infringe that right. So again, when we think of territory, we're thinking of any of the area that makes up that state. So again, the borders of Australia is an example. So let's have a look at some particular articles in the United Nations Charter that are important for you to know. So Article 2.1 confirms the equal sovereignty of all members of the United Nations. So these articles are upholding some of those rights of states that we've just looked at. Article 2.4 of the Charter adopts the idea that the use of force or threat of force against the territorial integrity or political independence of any state should not be the norm in international relations. There is an exemption in Article 51, which is stating that force can be used in self-defense. So again, we just looked at territorial integrity and political independence. So that's where Article 2.1 comes in to protect those rights of states. Article 2.7 ensures the independence of states from UN interference, so United Nations interference, in domestic matters within a state, with the exception of matters that are potentially deemed a threat to international security. So you can see that there are a lot of different things that have stipulations to say that it's not completely absolute. You do have exceptions because while countries do have their own rights, it has to be within reason. They can't be putting other countries and other systems under threat. So, explain the role of the UN, its agencies, and other organizations. So, there are a whole bunch of different organizations outside of the UN and then agencies within the UN that you need to understand and know how to explain. So, we'll have a look at each of these. So the role of the United Nations is to maintain international peace and security, protect human rights, deliver humanitarian aid, promote sustainable development, and uphold international law. So this is that idea that we just looked at. For example, in Article 2.7, it was saying that countries have the right to make decisions for their own territory. However, the UN is also stipulating that it can't be at the expense of international security. So that is because the United Nations is uh, responsible for looking after that global perspective, looking after the peace and the security and the human rights in international law globally. So it was formed after World War II to prevent the widespread destruction that happened in World War II from occurring again. There are a bunch of different agencies and organizations. So we've got the World Health Organization, or WHO, the International Monetary Fund, the World Bank Group, and then the UN High Commissioner for Human Rights and also the High Commissioner for Refugees. So let's start off with WHO. So we heard a lot about the World Health Organization back when we had the COVID-19 pandemic. So WHO coordinates action on international health issues, sanitation, and diseases. And the objective is the attainment by all people of the highest possible level of health. The International Monetary Fund, of course, is all about finances and money. So it's aiming to foster global monetary cooperation, secure financial stability, facilitate international trade, promote high employment and sustainable economic growth, and reduce poverty around the world. So all of those things that come under that banner of money, finances, the economy, making sure that it's looking after that on that global level. So this monetary fund acts as a forum for advice, negotiation, and assistance on financial issues. And although the IMF has a formal relationship agreement with the UN, it also retains its independence as well. The World Bank Group consists of 5 international organizations that make loans to developing countries. So it focuses on poverty reduction and improving living standards worldwide through low interest loans, interest free credit, and grants for all of those developing countries that need help in really important areas like education, health, infrastructure, environmental protection, and communications. We've got 2 different High Commissioners to look at as well. So the UN High Commissioner for Human Rights coordinates human rights activities and supervises the Human Rights Council in Geneva. So they work to protect and promote human rights that are guaranteed under international law and specified in the Universal Declaration of Human Rights. They also promote human rights that are yet to be recognized in international law. So they're looking at what is needed in society, what human rights are yet to be recognized, and what it can do to help promote those to bring about better outcomes for everyone, pretty much. And then the UN High Commissioner for Refugees is tasked with leading and coordinating the international efforts to protect refugees and resolve refugee problems across the globe. So the UNHCR works to ensure that everyone can exercise the right to seek asylum and find safe refuge in another state. So they also have the option to return home voluntarily, integrate locally, or resettle in a third country. So another thing to keep in mind, not only do you need to know what these things are, but also just try and memorize the acronyms as well. It's handy to understand what those acronyms are in case you get any kind of question or stimulus that only uses the acronym. It's good to have that understanding yourself. Part 5 of the Topic 1 syllabus, we've got key human rights initiated in these different important legal documents. We've got different acts and then also the Magna Carta. So the Magna Carta came about back in 1215, so it is a very old document, and it provided a modern platform to the provision of human rights and the development of a constitution. So the document is considered a cornerstone in human rights protection in the English-speaking world, and so it was modern back in its day. It was something that was really big in society, and it provided many of the fundamental rights that we now see today. So Clause 39 cemented the concept of innocent until proven guilty, which is something that we hear about all the time, and that our legal system follows. And so that's about you're not to be treated as guilty until you're proven guilty by a jury of peers, and you also have the right to bail as well. It also advanced the ideas of freedom, justice, and the rule of law, and these are principles which have become enshrined in our democracy. So it established the principles of due process and equality before the law, such as the right to a trial by jury and not being held imprisoned without the prospect of a fair trial. It enshrined the right of the church to be free from government influence, as well as the rights of all citizens to own and inherit property. And lastly, it guaranteed protection from excessive or arbitrary taxes, and it promoted the right of widows who owned property to choose not to remarry. So obviously we've had issues with lack of equality in terms of gender, and so this Magna Carta was really pivotal in terms of giving widows who've lost their husbands that right to choose not to remarry, even though they owned property. They have the right to own it themselves without needing to marry, so it's under the control of their husband. The Racial Discrimination Act 1975, which is a Commonwealth Act, promotes the human right of equality before the law for all people, and that's regardless of race, color, or national or ethnic origin. And the Act promotes human rights and fundamental freedoms in all different areas. So political, economic, social, cultural, and any other field of public life. So we've got the right to vote regardless of your race, the right to education, and the right to freedom of thought, conscience, and religion. So the Sex Discrimination Act 1984 is, of course, promoting the human right of freedom from discrimination on the grounds of sex, but then also on the grounds of sexual orientation, gender identity, intersex status, marital or relationship status, pregnancy, potential pregnancy, breastfeeding, or family responsibilities, or involving sexual harassment. So you can see that again, we've got this idea of different discrimination acts that are based on key issues or key areas where people have faced discrimination before, and in some cases continue to face discrimination. The Disability Discrimination Act promotes the human right of freedom from discrimination for anyone with a disability. So they are protected from discrimination in terms of employment, education, access to services and facilities, and public areas. And it makes disability discrimination unlawful, and it promotes equal rights, equal opportunity, and equal access for people with disabilities. So some examples of disability discrimination that may exist in society. So a school policy that doesn't allow students with disabilities to go on excursions would be an example of disability discrimination. Any insurance policies that have a blanket ban on mental health conditions. A shop that only accepts a driver's license as an ID, and not everyone has a driver's license for various reasons. Not considering a job applicant who uses a mobility scooter or any other sort of tools or devices that they need to function or to get around. Not allowing a staff member to bring their assistance dog to work. So someone who is visually impaired may need an assistant dog to get around and to work. So not allowing them to have that assistance dog would be discrimination. Bullying a staff member with an intellectual disability is also, of course, disability discrimination. And another aspect of the topic 1 human rights is being able to explain the role of the Australian Constitution. And this includes the foreign affairs power that is in section 51. And this is where we are looking at express and implied human rights in Australia, which is something that I've mentioned a few times already. So this is the last part of topic 1, and then we'll be moving on to topic 3. So section 51, under the foreign affairs power in this section of the Australian Constitution, the Parliament has the power to make laws for the peace, order and good government of the Commonwealth with respect to external affairs. So this idea of foreign affairs power. So this means that the Commonwealth can enact laws which are a faithful implementation of those international treaties or conventions that Australia is party to. And so that means that it's protecting express and implied human rights in Australia. So it can't enact laws which aren't in line with those international treaties. It has to make sure it's aligned with those treaties and then enact laws that are protecting express and implied human rights that are within Australia. So express rights. The Australian Constitution is protecting express rights in Australia by explicitly detailing 5 human rights which Australians are entitled to enjoy. So those rights that we have in our Constitution are the right to vote in section 41, the protection against acquisition of property on unjust terms, section 51, the right to trial by jury, which we've heard a few times, section 80, freedom of religion, section 116, and prohibition of discrimination on the basis of state of residency. So regardless of what state you live in, you should be treated equally and not discriminated against. The express enshrinement of these human rights in Australia acts to protect the human rights by prohibiting any Commonwealth law, so any federal law that could infringe on those rights. So those 5 rights are not able to be broken in any way. The government cannot pass any legislation that goes against those rights or obstructs them in any way. On the other hand, we also have implied rights. So these are rights that are derived from interpretations of the Australian Constitution, but they're not specifically outlined. So we do have that idea that they're open to interpretation, and different interpretations can contrast each other. So the right to freedom of political communication, the right to free speech, and the right to democratic representation are examples of implied rights in our Constitution. So an example of a case where implied rights were relevant. So in Lang versus the Australian Broadcasting Corporation, or the ABC, in 1997, the High Court confirmed the implied right of free speech in the Constitution, finding that freedom of communication on matters of government and political affairs is an indispensable part of the system of representative government. So this right is limited to what is necessary for the effective operation of the system of representative and responsible government. So it's interesting here how an implied right was relevant in a high court ruling. So even though they're not express rights, they still are important in society, and they still can have a bearing on important decision making and outcomes for people. Okay, we're now on to topic 3, human rights in Australian contexts. So this is now new content. Topic 1 is something that you will have hopefully covered for your previous piece of assessment, your inquiry report, as part of Unit 4, Topic 1. Unit 4 in terms of the IA3 task. But now we're on to the external exam topic, topic 3, and this is only in the external exam. You won't have covered it previously. So the first section of the syllabus we'll be looking at is asking you to explain and analyze the rights that Australians have in criminal and civil contexts. So again, this idea of the role of express and implied rights in ensuring equality under the law. And we've got those different aspects that we've seen some of already. So because we've already looked at human rights, and now we're looking at human rights specifically in Australia, there is going to be some overlap. There is going to be some relationships between what you've already seen and what we'll be looking at now. So first off, we've got free speech. So again, the Australian Constitution doesn't specifically outline the right to free speech. It's not an express right, it's an implied right. But the two elements that exist for free speech are freedom of opinion and freedom of expression. So freedom of opinion is the right to hold opinions without interference. There are no exceptions to this right, and there are no restrictions on that right either. It is an implied right, but it isn't restricted in any way. Freedom of expression is the other aspect, and this is your right to use any medium, including written or oral communication, the media, public protest, broadcasting, artistic works, and commercial advertising. So you can use any of those different mediums to express your views. The right is restricted in areas like posting on the internet, urging any kind of violence, inciting violence, and publishing defamatory information about someone. And the right protects unpopular ideas as well as unfavorable ones, subject to some limitations and restrictions. So you've got different limitations, just like you have limitations in most things for freedom of expression, because you still have to be expressing things respectfully. You can't be using expression to cause negative outcomes with violence and things like that. So Australian laws seek to protect these freedoms while also protecting people from unfair treatment and discrimination. That idea that, yes, you do have the right to express yourself and speak freely, but you can't do that in a way that is harmful to others. So there are some laws in Australia that help the country to achieve that balance between free speech and protecting people from discrimination. So we've got the Defamation Act. So this is protecting a person's good name and integrity against false information. So people can't make false claims about someone, which would defame them, or in other words, harm their reputation. And so, yeah, we can't just throw around different accusations against someone that aren't true. Anti-Discrimination Act 1991. This is in Queensland, just like all of these ones we've got here are in Queensland. It's illegal to incite others to hatred, so to compel others to feel hatred to other groups or people. Serious contempt or severe ridicule of a person because of their race, religion, sexuality, or gender identity. And then the Racial Discrimination Act is more specific. So race is part of that Anti-Discrimination Act, but we've also got the Racial Discrimination Act, which stipulates that it's illegal to commit an act likely to offend, insult, humiliate, or intimidate another person or group if you are doing it because of their race, their color, or national or ethnic origin. You also have the right to protest and freedom of assembly and association. So the right to peaceful assembly protects the rights of individuals and groups to meet and to engage in peaceful protest. And the right to freedom of association protects the right to form or join associations to pursue common goals. In Queensland, these rights are governed by the Peaceful Assembly Act 1992, and this act requires that any public protest or assembly must be authorised by the police and any other relevant local authorities. So you may have to approach the local council and the police department to get permission to hold your protest. That way that they're aware of it, they can approve it, and they can put anything in place to make sure that that protest stays peaceful and doesn't get out of hand. So these rights are express rights in the Human Rights Act 2019, which was introduced in Queensland, but they're not express rights in the Australian Constitution. So we do have differences there between the state and the country as a whole. So the International Covenant on Civil and Political Rights, which we looked at earlier, in Article 21, it says that everyone should have the right to peaceful assembly. And in Article 22, everyone should have the right to freedom of association with others. So we've got the express rights in the Human Rights Act in Queensland and in the ICCPR, but it isn't in the Australian Constitution at the moment. We've got this idea of freedom from discrimination. You'll have noticed that discrimination is something that keeps cropping up in human rights, and for good reason, of course. Discrimination is something that's very relevant to human rights and making sure everyone's treated fairly and equally. So Australia ratified the International Convention on the Elimination of All Forms of Racial Discrimination in 1975. Article 1 of the convention gives us a definition of what racial discrimination is. So, any distinction, exclusion, restriction, or preference based on race, colour, descent, or national or ethnic origin, which has the purpose or effect of nullifying or impairing the recognition, enjoyment, or exercise on an equal footing of human rights and fundamental freedoms in the political, economic, social, cultural, and any other field of public life. So this is where we're looking at all of those different areas where people may be discriminated against, race, color, etc. And it's saying that anything that is preventing the recognition, enjoyment, and exercise equally to others of human rights and freedoms in any of those public life areas it is not allowed. So there are several federal laws that guarantee freedom from discrimination. So we've got the Racial Discrimination Act, the Sexual Discrimination Act, the Australian Human Rights Commission Act, the Disability Discrimination Act, the Fair Work Act, and the Workplace Gender Equality Act. So it is interesting to look as well at the years associated with each of these acts and see what were the key issues across the different generations and when things came about. So in Queensland, the primary law that protects your right to freedom from discrimination is the Anti-Discrimination Act. And Commonwealth laws and state and territory laws generally overlap and prohibit the same type of discrimination, which is what you'd expect. You would hope that the federal level and the state and territory level are on that similar wavelength to make sure that there's cohesion across the country. Democratic representation. So the commitment to representative government, that's something that's embedded in the Constitution. So that idea of representative government is having a democracy where we elect a group of people who are representing our interests and are working as part of that government body to advocate for those interests and make decisions that are in our best interests. So sections 7 and 24 of the Constitution say that both houses of the federal parliament are to be directly chosen by the people. So that idea that we are able to vote directly to choose the federal parliament. And sections 8 and 30, when choosing members of parliament, each elector shall vote only once. So one person equals one vote. And that is basically saying that regardless of who you are, what your sort of status is in society, financially or any other way, everyone is equal. Everyone gets one vote regardless of that. There are a few exceptions in terms of who can and can't vote. Of course, you do need to be 18 years old to vote. And then once you reach that age of 18, it is compulsory for you to vote. Prisoners serving a prison sentence of 3 years or fewer can also vote in federal elections and referendums. They can't vote in Queensland state or local elections, though. That is an exception there. So, of course, anyone who can't vote, people under the age of 18, anyone who isn't validly enrolled at the time of an election, people who have a mental illness that prevents them from understanding what it means to vote, and then anyone who is a convicted and serving person in prison, serving a time of more than 3 years. Freedom of religion. So we can see we've got different levels here. So in terms of the federal level, Section 116 of the Constitution prohibits the federal parliament from enacting laws that establish any religion, that impose any religious observance, and prohibit the free exercise of any religion. So everyone has the right to follow whatever religion they choose. The government can't establish religions or pose any kind of restrictions on religions through their laws and their decisions around those. It also prevents the Commonwealth from making religious tests a compulsory qualification to hold any office or public trust. So to hold any sort of position like that, you don't need to complete or pass any particular religious tests. That's not something that's part of your qualifications to be in that position. In Queensland, we've got the right to religion, freedom of religion being protected by the Anti-Discrimination Act. So it's illegal to discriminate against a person based on religious belief or activity. And then Section 20 of the Human Rights Act 2019 in Queensland stipulates that we have the freedom of thought, conscience, religion, and belief. Now, in the ICCPR, the International Convention on Civil and Political Rights, we've got Article 18 that also says that we've got the right to freedom of thought, conscience, and religion as well. So some overlap there with the Queensland legislation. Trial by jury. So this is another right that we've mentioned already. It's considered the cornerstone of Australia's criminal justice system. So Section 80 of our Australian Constitution says that Australians have the right to trial by jury for Commonwealth offences. So the trial on indictment of any offence against any law of the Commonwealth shall be by jury, and every trial shall be held in the state where the offence was committed. So even if you're from a different state, you are to be tried in the state where you committed the offence. So the right only applies to trials on indictment. So this is about serious offences. It doesn't apply to offences that can be tried only in a magistrate's court. So this is about high-level offences that need to be heard in higher courts. Magistrates' courts are the bottom of the hierarchy of courts. And the jury's verdict has to be unanimous as well. Everyone has to agree on the verdict. The Magna Carta also aligns with this. So it says that a free person could not be imprisoned except by the legal judgment of his peer or by the law of the land. So this idea of peers making decisions. part 2 of 3 for the topic 3 of human rights in Australian contexts. We need to be able to explain the legal processes available to citizens for resolving human rights complaints. So there are a bunch of things here to go through. So let's start off with protesting. So to stage a public protest, you have to get authorization from the police and any other relevant authorities like the local council, which is something we mentioned earlier. And so this involves providing any of those relevant authorities with a notice of intention to hold the protest, and then not only doing that, but then also getting their approval to go ahead with the protest. So protests are unlikely to resolve human rights complaints, and outcomes are informal and unpredictable. So with enough support, though, protests can lead to changes in laws, but this is unlikely to result from just a single protest. You need a lot of push from protests to get sort of tangible outcomes. So if you think about having series of protests, if you have enough support behind them, then that is where you can potentially make some change in society. And a more likely and less formal outcome of protests is just increased awareness of the issue, because the media is usually going to cover protests, especially larger ones, and then that media coverage results in greater awareness in society. And that, while it may not be what the protesters wanted to achieve in terms of legal outcomes, awareness is definitely important, and it is the first step towards greater change. So lobbying is any attempt to influence the decision making of a government or the opposition representative in the exercise of their official functions. So any lobbyist who acts on behalf of third-party clients for the purposes of lobbying an Australian government representative, they need to be registered, and they need to comply with the requirements of the lobbying code of conduct. So it is a regulated area. You do have to be registered and to comply with certain rules. So you can hear about lobbying on all different levels. There are lobby groups that you can join that have different interests, and they can be lobbying in different ways. You can have formal or informal kind of lobbying. Perhaps you're attending meetings and you've got a formal process where you're voicing your views in front of your members of parliament, for example. Or you could have less formal versions where you're trying to contact them. Maybe you're sending emails or letters, or you're staging sort of grassroots campaigns and things like that. Lodging complaints, of course, is another way you can resolve issues. So to lodge a complaint with the Australian Human Rights Commission, or the AHRC, the complaint has to be in writing, and it has to include all the details that are relating to what you're complaining about. So the individual making the complaint has to prove who breached their human rights, and that what occurred was unlawful, and that the damage or harm was suffered because of what was done. So that can be tricky, that idea of causation, to prove. So where appropriate, the Commission will invite parties to participate in conciliation, and that is an informal process, and it allows the complainant, so the person who's lodging the complaint, and the respondent, the person who has been complained against, to discuss the issues in that complaint to attempt to resolve the matter. So we have different in criminal law, we have different things that are available with mediation to try and allow people to resolve their matters without going to court. So this is an example of that sort of informal process that's allowing people to try and figure out the issues in a more informal context. If the matter doesn't get resolved through that process, then the Commission may request more information before making a decision themselves based on all of that information. Tribunal and court actions. So this is the next level. So this is a formal method of resolving human rights complaints in Australia. And court action requires the parties to follow a really specific set of processes and rules in a formal hierarchical kind of system. So judges or magistrates are restricted by legislation and precedent in terms of the outcomes they can apply. So they have to look at any relevant precedent cases. They have to look at the legislation that exists and make their decision based on that. However, there is definitely some outcomes for the resolution of the complaint. So while court or tribunal decisions may be appealed, the outcomes are enforceable. So the parties who are involved may appeal and say that they disagree with the result and lodge their interest in having another hearing, but the court may not accept that. It could allow that, in which case you would have the process again, things would be redone and reviewed, but the outcomes can also be enforceable, where the court can just dismiss an attempt to appeal a decision. And the last part of the syllabus that we're going to look at today involves looking at the role of the different groups that protect and advocate for human rights in Australia. So just note that there are other parts of the syllabus in topic 3 that are asking you to be able to analyze and evaluate, choose information from pieces of stimulus and respond accordingly with analysis and evaluation. But that is not what we're going to be looking at today. We're just covering today all of the different explaining and describing things that you need to know. So you have all of that base knowledge. And I would encourage you to come back for our September lecture series, where we'll be doing more exam revision. In that lecture, we'll be looking at revising some of this content so you have a bit of a refresher, but we'll also have more of a focus on practice questions, example responses, and the analysis and the evaluation aspects to really boost you in those areas and to get you thinking critically about things and writing really well as well. So we've got a whole bunch of different groups that we're looking at now in terms of their role in protecting and advocating for human rights. So let's have a look at each of these. So we've got the Australian Human Rights Commission, and this organisation can investigate and resolve complaints of discrimination, harassment, and bullying based on a person's sex, disability, race, or age. And we've got those different acts that relate to those different areas as well. It can also investigate and resolve complaints based on other aspects of a person. So their criminal record, their trade union activity, political opinion, religion, or social origin. So it's really quite broad here with all of the different areas that someone may face discrimination. So it also resolves complaints about alleged breaches of human rights against the Commonwealth and any of its agencies. So in Australia, it's against the law to be discriminated against in many areas of public life. So it's anything from employment to education, the provision of goods and services and facilities. So when you're buying things, when you're getting services from people, you can't be discriminated against. Accommodation, and of course, sport as well. The Australian Law Reform Commission. So this is an independent commission, so it's not part of the government. It's a third party that conducts inquiries into areas of law at the request of the Commonwealth Attorney General. So it makes recommendations to the government so the government can make informed decisions about law reform. So just like we saw earlier about royal commissions, looking at investigating different areas and looking at what needs to be done, what the best courses of action are. So this commission undertakes research, it does consultations, and it develops legal policy, and then ultimately makes recommendations with several different aims. So they aim to bring the law in line with current conditions and needs. Of course, things change over time, so we need to continue to monitor society and the things that are happening to make sure our laws reflect those conditions and people's interests. Remove any defects in the law. The law is not ever going to ultimately be perfect. There are things that are going to change, things that will come up in decision making that perhaps aren't the best way of doing things. So making sure that they recognize loopholes or issues and are able to fix them. Simplifying the law. Of course, the law can be complicated, but it should be as simple as possible. So ultimately, we have that fairness between different decisions. That consistency is easier to achieve if we have simplicity. Adopt new or more effective methods of administering the law and dispensing justice, and then provide improved access to justice as well, so everyone is able to access the justice system. The Commission also monitors overseas legal systems, and the idea of this is they want Australia to stay up to date with international best practices. So, of course, we can learn from other countries in terms of what they're doing and think about how that can inform what we choose to do in Australia. We also have a Queensland-based Law Reform Commission. So this is an independent statutory body established under the Law Reform Act, which is a Queensland Act. The key duty of this commission is to do law reform reviews, and those are also referred to it by the Attorney General. The Queensland Council for Civil Liberties is a voluntary organisation that protects individuals' rights and civil liberties. And the Australian Human Rights Centre is an advocacy source for human rights in Australia. It's aiming to promote public awareness about domestic and international human rights standards, laws and procedures. So it does research projects education programs, and it publishes different things as well to try and advocate for human rights. Australian Lawyers for Human Rights is an association of legal professionals, and they practice and promote awareness of international human rights standards as well. So it wants to try and get federal, state, and territory laws to comply with international human rights law. It engages with the United Nations about Australian human rights violations, and it also engages internationally to promote human rights and the rule of law. Amnesty International. So this is a non-government organization, and it has campaigns and it advocates for the protection of human rights independent of any political ideology, economic interest, or religion. So again, that non-government third-party organization. And the International Federation of the Red Cross, or the IFRC. It does relief operations to assist victims of disasters and health emergencies, and it also helps communities in developing countries. And of course, the media as well. So this is something that may not come to mind when we think about different organizations that help to uphold human rights. But the media does play a really important role because it can expose human rights violations, and it can allow different perspectives to be heard, give different people a voice, so the issues in society are recognized and things can be done to protect human rights and to keep the government accountable. So an example in terms of children in detention. So across 2015 and 2016, the media published hundreds of articles on child detention abuses at Dondale Youth Detention Centre. And that media coverage actually resulted in some action. So the Prime Minister at the time called for a royal commission, so that high-level inquiry into that issue. And that meant that it was fully investigated and that recommendations were made to the government to improve the systems that were in place. So that demonstrated that the media can generate community concern about an issue and awareness about an issue, especially in terms of issues that aren't in public view. So we don't see youth detention facilities, what happens inside those facilities, just like we don't see other things in society. So bringing that to the forefront of people's minds, and then allowing justice to prevail based on that that awareness that we've gained. So to finish off, I wanted to give a few tips to help you achieve the best that you can in legal studies. So as I mentioned earlier, everything that we've covered today is directly from the syllabus. And so I encourage you to read the syllabus, get to know the requirements for each unit and topic. You may feel like it's too late now if you're nearly finished Year 12, but I actually only discovered the syllabus and how useful it is right at the end of Year 12 as well, before my external exams. So you've got even more time than me to make the most of the syllabus and the sort of guidance it can give you. Use it as a study guide, because ultimately anything that is in the syllabus in the relevant unit and topic for the piece of assessment that you're doing could be on your exam. And you can't be assessed on anything that isn't in the syllabus. So it is your ultimate guide to make sure you're on the right track. Also, of course, access past external exam papers on the QCEE website and try and use these to practice. So these will allow you to sort of get the idea of the structure and the requirements of the exam, and if you do them in exam conditions, you'll also get a feel for the timing, and get yourself to sort of be in that mindset of being on the clock, and needing to make sure you're fitting in everything in that time period. So if you go to that QR code on the screen, you'll be able to access the syllabus, and it's also easy to access if you just visit the QCEE website as well. And that's also where you'll find the past exam papers and also a bunch of other resources around definitions that you could find useful, analytical verbs, and other assignment examples as well if you aren't in year 12 yet, or you are yet to complete earlier pieces of assessment. That could also be handy as well. Thank you so much for coming along to today's lecture. I hope that you found everything that we covered today helpful. I encourage you to register at atonnotes.com if you feel like you could benefit from any additional help, and I hope to see you in future lectures. Thanks, everyone. Bye.